Well, thank you, Lori, for that very kind introduction. Good to see all of you here today. Lots of familiar faces. And the patent discussion in Washington continues unabated. So I always view it as the Mike Waring Full Employment Act, but that's okay. Anyway, I'm really happy to be here with this panel this morning to really look at how patents do drive 21st century jobs. And the goal of this panel really is to sort of look at what's on the horizon in terms of new innovations and discoveries that are waiting to happen, and how the patent system either is or is not working to help advance those inventions. We have with us representatives of two innovative companies, the head of an association of university tech transfer professionals, and a patent law expert for the venture capital community, all to provide some perspectives on those topics today here. And hopefully we'll all be educated a little bit about the opportunities and the challenges that innovators face here in 2017. Let me just introduce our panelists real quickly. Starting immediately to my right is Kevin Rhodes, Vice President, Chief IP Counsel for the 3M Company. He also serves as President of IPO. He's also been a member of the Coalition for 21st Century Patent Reform. Next to him is Susie Armstrong, Senior Vice President of Engineering for Qualcomm. She was very involved in helping bring internet protocols to the cellular telephone industry and helped Qualcomm develop packet data in the late 1990s. Most recently, she's joined the Government Affairs Group, where she brings her engineering and product background to bear on worldwide public policy, including IP protection, trade, immigration reform, and STEM issues. Next to Susie is Steve Susalka, who is CEO of the Association of University Technology Managers, or shorthand AUTM, which represents over 3,000 tech transfer professionals worldwide and here in the U.S. Steve has more than 10 years' experience in tech transfer, helped create a number of startups. He was most recently at Wake Forest University. Before that, did licensing for the University of Virginia Patent Foundation. He actually has a doctorate in neuroscience, so if anybody has a headache later, see Steve, he'll take care of you. And way down at the end, last but certainly not least, Bob Taylor, founder and owner of RPT Legal Strategies in San Francisco and Palo Alto, also serves as a venture advisor to the New Enterprise Associates and as a patent law expert for the National Venture Capital Association. He's been doing patent litigation for over 30 years, and for many years he co-chaired the Antitrust Committee of IPO. So thanks to all these folks for being with us today to bring their perspectives on our topic at hand. And so rather than just have each of them do a presentation with slides and that sort of thing, what we're really going to do, I'm going to try to just interview them for the next little while here and talk about some of these issues and bring out the information in that way. Hopefully they'll pick up on each other's comments as we go forward. And then later on, we'll have a chance for you all to jump into the discussion with questions and comments, so please be ready to engage with us. I see microphones on either side of the room, so please feel free to use those and identify yourself when you have a question or comment. So I'm going to start with Kevin from 3M. Clearly, 3M is a company with a long history of innovation. And so, Kevin, kind of what's your company's general view about the patent system and the role it plays in innovation? So,
okay. Yeah. Thank you, Mike. Good morning, everyone. It's great to be here, have an opportunity to talk about American innovation and to get to share the stage and the room with inventors and a distinguished lineup of IP professionals. And, you know, innovation is a subject that has been the cornerstone of 3M's success for our 115 years that we've been in existence. Today, we invest about $1.6 billion a year in our R&D. We have 46 different technology platforms, everything from abrasives and adhesives, sort of the foundation of 3M as an industrial company, to sensors and electronics and software technology platforms. We take those technologies and we combine them into products to the tune of about 55,000 different products. We tend to place our bets on innovation and on our commercialization in areas where we can be the market leader. So as a result, we try to be into the market early with innovative technologies, and we try to preserve that differentiation in the marketplace through legal rights such as patents. So patents really provide for us the legal foundation to secure the investments that are often, lengthy, costly, and uncertain in R&D and commercialization and manufacturing and in jobs for our products. So patents are really, and other forms of IP, but particularly patents, are really integrated into our business model. They provide that foundation upon which we innovate and we allocate our both R&D and commercialization investments.
So Kevin, we all know about Post-it notes, a great invention, sort of serendipitous invention.
Yeah.
But what are some of the latest innovations your company's working on these days? What do you think we'll see in the next few years coming out of 3M that will be kind of cool new things?
So I think, Mike, sort of across the board of those 55,000 products, a common theme that really is playing out at 3M and I think many other companies is increasing information and communications technologies. So really digitization and electronic content in our products. And that's everything from, sort of our traditional industrial and materials businesses, so such things, for example, as connected roadways. So, we have a long-standing business in reflective sheeting that's used on signage, on pavement markings. Those are being enabled with communications protocols to communicate with autonomous vehicles. So you've all heard of, the autonomous vehicles, and we think of those and the timeline to get to those, which is anticipated by 2030, we'll have fully autonomous vehicles. We think about the positioning of those by GPS, but in reality, you need redundant systems because anybody who's tried to use your GPS tracker in your car, I mean, recalculating is probably not an option when your car is driving itself, right? So, so you need to communicate with pavement markings, with signs, with perhaps transmitters along the roadways, so we can use our materials expertise to branch out and create that ecosystem, that autonomous driving ecosystem. And so we'll get into this, Mike, but some of the challenges in patenting those types of inventions that go into electronics and software are challenges that we're facing in our IP function right now. Similar story, one other example is asthma inhalers. So asthma inhalers are 50 years old. They tend to be sort of just purely mechanical devices today. We're developing a digital inhaler that not only measures the quality of your breathing and the dosage of the medicament and how much is left and when you have to take your next dose, but also can communicate with your healthcare provider, with healthcare payors, and really coordinate your treatment. And so that's another example where old technology with the medicament and the mechanical delivery with the actuator, the dose canner, is being digitized for the modern economy.
That's great. That's great. Well, autonomous vehicles, you're singing the University of Michigan song because we are one of the leaders in that whole area. In fact, we have the only test track for autonomous vehicles in the United States right now, which we build ourselves on campus. And they're building another one nearby, but we're all over that issue, so that's great. Susie, I want to talk to you. Obviously, Qualcomm, it's like 3M, very innovative company, been around for decades. What are some of the new things that you guys are working on there?
Well, I just decided right now that Kevin and I are going to create a company. You can join, and we're going to do connected roadways.
I like it. I like it. I'm all over it.
But we're a systems company, and we're basically at the heart of everything you love about your cell phone. We do everything we do pretty much everything that lies below the surface of wireless communications, both broadband, Bluetooth, Wi-Fi. And a lot of the things that we're working on now are the engines, if you will, that drive the things like flying drones and autonomous cars. And one of my colleagues said, so Susie, you're going to try to make semiconductor process technology sexy in this talk? And I'm not going to go that far. But the point is that all these things require incredible investment, and that investment only comes when it's protected by a set of patents. Whether you're doing materials research or you're doing building systems or you're trying to create low-power chips to go in watershed management that only have to have a battery replaced every 10 years. These are not things that just fall out of the sky or somebody wakes up and invents and they put into place the next week. These are all things that require tremendous risk, defining the use cases, and that's what Qualcomm does, is we build every engine there is to drive any sort of wireless communications. But more than that, anything that runs on top of wireless communications, we often are doing research and filing patents on and investing in so that we can drive that mobile that mobile technology. I think the BCG report that came out in 2015 talked about something like 11 million jobs in the whole mobile industry. And so it's not just the patents and the good and the investment that comes to Qualcomm that comes out of these new technologies and products. It's also what that gives rise to in the broader industry, the apps and the connected roadways and these kinds of things.
So what about your view? How does, now, Kevin shared there sort of the 3M view of the role patents play. How does Qualcomm view it? In a similar vein?
Yeah, so Qualcomm, and I, being an engineer for 23 years in Qualcomm, and 10 years before that at Xerox, I sort of lived this. And I joined Qualcomm in the early 90s when we were just trying to get CDMA out the door and accepted by the industry and the community who said it would never work. We had to invest a tremendous amount of money in building not only what we build now, the chipsets and such, but building phones, building base stations, building the infrastructure, because we had to show that this worked. And that kind of investment is only possible when you're confident you're going to have patents and a strong patent system to protect it. And that it also, you know, we believe at Qualcomm, and I believe it's sort of a snowball effect. When you have that kind of innovation and you have the patents to protect it and incentivize the investment, then in the 2000s, we hired thousands of engineers to work on the technologies that CDMA first gave rise to. And, you know, Mike mentioned that I worked on the early internet software. We surfed the net on this phone in 1997 at the CTIA show on this screen, and we're very proud. But these kinds of things on the voice channel at 14 kilobits a second, and we're very, very proud. But these kinds of, the point is that these kinds of inventions, if you will, lead to other inventions. We spent the next 10 years, other inventions and other jobs, and we spent the next 10 years doing things like adding camera capabilities. So you went from this phone to this phone, display capabilities, faster and faster and more responsive air links. And so that's sort of the history of Qualcomm and inventions. And going forward, we also need that kind of patent protection so that we can invest in IoT in our new company with autonomous driving vehicles and magnetic wireless charging roadways. And without that in investment, you can't hire the engineers and the researchers to make these innovations, and without the patents to protect that investment, it just doesn't go anywhere.
So Steve, university technology folks are at the very front end of this whole innovation continuum from the lab to the marketplace, and most of the ideas that we churn out are pretty early stage. They need more work to be fully developed to become a commercializable product. So what are some of the success stories we've seen in the past from that process? And kind of what are the challenges that people in your profession face as they try to figure out which discoveries on their campus are going to be the next great product to get to the marketplace?
Sure. So if there are two things that I'd like you to remember from at least my segment of this presentation, number one is universities are the breeding ground for the next generation of inventions. Companies as well have a tremendous capability and success in doing that, but universities create so many of those inventions that you've already used today, will use tomorrow, wearing today, and so on. So that's the first thing I want you to know. The second thing is the critical link between a university that invents that technology, but of course, universities don't sell products, companies sell products. That link is intellectual property protection, and the importance of a strong patent system in allowing that transmission from an invention to a commercial product. So let me give you a couple of examples. And there's so many, I'm just going to hit a couple. Right now, you guys have vitamin D fortified milk in your coffee. You can thank the University of Wisconsin for developing that process. You are probably wearing new fabrics that were developed at North Carolina State. If you are an allergy sufferer, you can thank Georgetown for the creation of Allegra. Laser cataract surgery, MRIs, CAT scans, 153 drugs, vaccines, and new indications that have been FDA approved all came from public sector research institutions. So there is just a remarkable amount of intellectual property that is developed at universities. And as a taxpayer, as you are, I'm happy to see that my tax funds are being used in part to support research. That research is leading to those next generation of drugs and devices, and it's not all medical. There are engineering, LED lights, for example. There is a whole host of other inventions that have been developed out of universities. I will tell you this has gotten much more personal for me in the last week, and that is my father had quadruple bypass surgery last week. And thanks to the University of Minnesota, who developed the first heart-lung transplant or heart-lung device that kept my father alive during that open heart surgery, he's around today. So again, that's a personal question, or it's a personal statement on the importance of intellectual property developed at universities.
Well, and just to build on that, Steve, I know that in the last couple of weeks, Autumn and the Biotech Association, put out a joint report that kind of talked about all the economic impact of this work over the last 20 years. Why don't you speak to a couple of the high points of that report?
Sure. So, at the end of the day, it's about the products and the services that are created, impact on me, my family, you, your family. But you can also actually look at the economic impact. And so hopefully on each of your chairs, you guys saw a little flyer that describes some of the impact of university intellectual property. And so just to summarize, over a 20-year period, university technology transfer has led to up to $591 billion to the GDP in the U.S. That's sales of final sales of products and services. $1.33 trillion in gross output. That's kind of GDP plus all the stuff that happens in the middle. And up to 4.2 million jobs. So in addition to all those different inventions I described and others you're probably not even aware of, there is a significant economic impact both in GDP as well as jobs and new job creation. Also on the same page, what you'll see is just in 2015, the latest year we have data for, over 1,000 startup companies were created to take those next generation of inventions to market that will allow new products and services, new jobs, larger tax base. So university technology transfer is very important in the field.
Right. So Bob Taylor, you work very closely with the venture capital community that Steve's group depends on and others who are going to begin new businesses rely on to kickstart these new technologies. So what role are patents playing in the decisions that the venture capital community are making right now, and what trends do you see going on right now?
Certainly a lot of the companies funded by venture capital today still are very dependent on patents. Certainly on the medical device side, the biotech pharma side, and some of the non-healthcare related. However, the trend is more and more venture capital is going to companies with shorter horizons that don't require long-term investments that depend on patents. To some extent, that's because investors have become very jaded about the ability to enforce patents, the cost of enforcing patents, and the value of having patents. And so more and more venture capital funding is going into consumer product kinds of businesses, internet applications, and one of the things that you see, it's hard to quantify this trend, but when you see a company like Uber that has yet to make any profit and has a market valuation or a valuation for the purpose of transactions north of $70 billion. The reason for that is because a lot of the venture capital firms that are putting money into a company like Uber see it as a better investment than starting a new company that is going to depend on patents and that has a 4 or 5, maybe a 10-year horizon.
Interesting. Because, you watch that show, Shark Tank, and of course one of the first questions they always ask these inventors is, do you have a patent for this thing you've just invented? And I guess what you're saying is that the patent has become less important to the venture capital community.
To the community as a whole. Now, Kevin O'Leary is the guy that usually asks that question, and he is a passionate believer in the patent system. Right. And there are a lot of venture capitalists still that are, but the system itself is not functioning well enough to create the kinds of incentives to start new companies.
And what do you think has been the cause of that? Why is it because of the court decisions, or has it been the threat of legislation? What's been the trigger for that, do you think?
I'm reflecting on how to moderate what I say about that.
Okay, sure.
I think 15 years of a Supreme Court that doesn't have any understanding of the relationship between patents and innovation in America has left the system bereft of any real value for many of the startups that want to get started. And there's a decline in the number of companies that are starting new businesses. If you look at the data, I saw a report a couple of days ago from an organization in Chicago called EIG, and the data shows that up until 2008, for reaching back 30 years, we had a net growth of new companies coming into the pipeline. And since 2008, we've seen a decline in new companies. The failure of companies is greater than the number of new companies that are getting started. That has a long-term implication for our country.
Right. So Steve mentioned about the tech transfer, and they always rely on outside investment to sort of get this going, either from a company or from an investor, or an angel investor, a venture investor. So how would you characterize the relationship between the venture community and universities in general?
A lot of the venture capital startups are coming out of universities, and I think Steve's absolutely correct that it's critical to have patents as the linkage between the company and the university.
Right. Okay. So I want to engage all of our panelists here with sort of some thoughts about, as we view kind of the lay of the land, the landscape for patents these days. Let me get your views on that, and if anything needs to be done to make it work better. What would be some things that could be done to improve the system, if there was going to be? And let me just start with you, Kevin. From 3M's perspective, what needs to change to make the patent process work better so that you and your company and others can be more efficient, more innovative in the future?
Yeah, so I think Bob started to touch on it a little bit. I think in a couple different ways, the innovation ecosystem has evolved, and patent law needs to keep up, and we need to revisit some of the recent developments in the law. So the first way I think Bob alluded to is, the speed of innovation is faster than it's ever been. And some of these spaces that we were talking about moving into, the rate of change is just unprecedented. And so we need to make sure that, we talk at 3M about the legal department sort of working at the speed of business, right? So we have to be there to give advice in a timely manner that's useful to our business clients. Same thing for the patent system. The patent system needs to work at the speed of innovation in the modern economy. And I think, that's a challenge for the patent office to issue high-quality patents in a prompt way so they are meaningful at the early stages of development when you're trying to determine, if you're a company, whether to invest in that technology, if you're looking to attract investors, if you're a startup, or the university environment is exactly the same. I mean, patents provide that currency, that well-defined scope of rights that facilitate those transfers, so you can have an orderly sharing of information under the rubric of the legal rights, so where they lie and how the collaboration can take place. So that's issue one. Issue two then is, how reliable are patent rights, how enforceable are they? And I think that's where a couple of developments we really need to look at to see whether they are fostering our innovation economy. One is Section 101 jurisprudence, what is patent eligible subject matter. I think we're unfortunately in a situation right now where interpretation of the judicially created exceptions under Section 101 are denying patent eligibility to two of the most innovative sectors of our economy. Life sciences, in particular, personalized medicine, and computer-implemented inventions, and in particular, software. And I think, the implications for that are profound on the innovation policy in this country, and those are policy questions that need to be made and really owned by Congress. I think having that policy developed on a case-by-case basis over years by the courts in a series of decisions on judicially made exceptions is not the right way to set our innovation policy. That really needs to come from Congress. The other area I think to look at in particular is the PTAB and the post-issuance review proceedings that were created by the American Invents Act. I think the way those have been implemented by the office to the tune of the patent office issuing patents that are then invalidated upon review. And, pick your stat, 65, 70, 75% of the time, I think that's an unsustainable business model, that the very agency that's issuing those patents is saying that, the overwhelming majority of them are not valid upon challenge. And we talked about, both Susie and I talked about using patents to secure long-term investments in commercialization, in manufacturing, in jobs. At some point, there needs to be a sense of quiet title on those patents. So serial challenges throughout the life of a patent, and this is not just a random sampling of issued patents. Our most valuable patents, the ones that we want to use and that others want to use, are the most likely ones that we will have to enforce and the most likely ones that will draw a post-issuance review, an IPR. And so the serial nature of those challenges and never really being sure, when one will impact your patent, will knock out or limit your patent rights. It's a really tough discussion with decision makers on the business side right now about where they place investments if they can't rely on the patent rights that are constantly subject to challenge. And one of the implications of that is people are going to move to other forms of exclusivity, trade secrets or regulatory exclusivity, other ways to try to preserve that differentiation in the marketplace if patents are no longer a reliable differentiator. And that also has profound implications on our innovation economy and all the benefits of the patent system in terms of disclosure and innovation on top of those disclosures. We really need to think about what a move to other forms of exclusivity, legal exclusivity, would do to that policy.
Right. What about the rest of the panel? Other thoughts you might have about what are some of the things we need to address most directly, and what would be a solution that you might proffer if you have a thought about that?
Well, I am not an expert on patent policy or the legislature. I am a product of the patent system, but Qualcomm, to Bob's point here, with no disrespect to Uber, it takes thousands and thousands of people in the mobile industry on the base station side, on the phone side, on the chipset side, to build a platform for companies like Uber or other companies making small apps to be able to make them. And so it's very alarming to me to see this American innovation engine sort of being stalled by people who have a much more short-term focus. So that's troubling. On the other hand, Qualcomm, recognizing both the need for future inventors and the need for workforce development, most of the patents, I believe, come out of a STEM area, science, technology, engineering, math. And so Qualcomm, this gives me a chance to use my prop. Qualcomm has a program called, it's called the Think of It Lab, and it's a STEM engagement program. What we're trying to do is show these kids that I think the statistics are there's a gap of 1.1 million jobs in 2024 in people who are qualified in STEM fields to fill those gaps. So we started out with the Think a Bit Lab looking at workforce training, and then we realized that this American innovation engine going forward is dependent on, the young people and the kids actually believing in a patent system, believing in innovation, being able to produce rather than just consume. And so in the Think a Bit Lab, what we do is we bring kids in, and we do it all in the lens of careers in these areas. And we expose them to, we go through a strengths and interests and values area. We expose them to things like, IoT concepts, consumer electronics, smart cities, smart homes, and we expose them to careers that are going to be in those areas. And we actually use the Department of Labor's ONET for the statistics on this career. I think we have a political scientist here, so doesn't look so good in the upcoming it doesn't look so good in the upcoming years. But the point is, we want these kids to understand that they can invent the future, and we absolutely need a strong patent system to make sure that that innovation engine that provided, me with a job and thousands of, mobile industry with a job and pharmaceuticals with jobs, that industry and that patent industry is strong. And lastly, we target sixth graders right now, and mostly sixth graders from underserved areas, girls, minorities, people. There's a lot of good STEM programs out there, but a lot of them don't target. A lot of kids, especially in middle school, are not aware that, these are not exclusive, mysterious jobs, inventing and doing engineering. So this is my favorite IoT project done by a group of 3 sixth graders in the Think a Bit Lab in California. And what it is it's they go through this, they learn to program an Arduino board. This is all a one-day experience. And they then create an invention of their own making, and somebody should patent this. One of these kids should patent this. This is an invention that this group of kids created. These are little arms when you're sleeping in bed, and I like the dog next to you. When you're sleeping in bed and your alarm clock goes up in the morning, the arms look at a sensor, determine what clothes are dirty and what clothes are clean. It dresses you in bed, and then it puts on your makeup. So now, if we don't all need this, I don't know what we need. So the point is to make good on that promise of jobs and invention. We absolutely need to make sure that we have a strong patent system. So this thing we call the American innovation engine that we're so known for doesn't end up going awry, because without that kind of innovation and without that kind of investment, there's not a patent system, and there's not a set of jobs for these kids that are going into these STEM fields.
Yeah. So, but by the way, Susie will be selling these in the lobby afterwards. Not too soon to plan for Christmas here.
Your props are way better than mine.
Yeah, exactly. We need that road in here somehow, the connected cars.
One of the questions that I have for Susie, and let me give a preface to this. I had the privilege about 2 weeks ago of visiting a company in Southern California that is the only privately funded, at least that I know of, the only privately funded company that's doing research into power generation using nuclear fusion, atomic fusion. A number of European entities are doing this at the governmental level, but this is an entirely venture-backed company. It's had several $100 million in funding over a period of 20 years to create what, when it comes to pass, and it will transform the planet in exactly the same way the internet has. The internet has allowed us to deliver information at essentially zero marginal cost, and the creation of electrical energy at zero marginal cost is going to be just absolutely transformative. And this was a very exciting company to be in, but it was started in 1998. And in 1998, we had a patent system that justified those kinds of investments. You couldn't raise money today to start this company. You couldn't today start this company despite the promise as a result of our patent system. Susie, I'd like to know whether you think someone setting out right now to create another Qualcomm in the face of governments and companies telling you it can't be done, whether you could get that company off the ground.
I don't think that you actually could, because for two reasons. As I said before, with all due respect to these wonderful apps that run, there's a notion in the tech world that you don't need patents and you want to be rich or be bought in, by the way, you need patents to be bought.
Fair price.
Yeah, in 2 years. So that's a very alarming look, and I'm not sure the current situation would actually support a Qualcomm and a nuclear. These things require 10 years and millions of dollars and jobs to actually come to fruition. And I don't see, what alarms me is, to build this, what kind of system do we have? And that sort of American, that's what I mean by the American innovation engine. I'm not sure there's a stomach in the public or in the government with all these attacks on sort of the innovation engine and the patent system to create a Qualcomm.
Steve, so technology folk, tech transfer people are in the middle of this process, and what do you hear from your members? What are their concerns in this sphere? What keeps them awake at night worrying about the discoveries they have on their own campus as they deal with this system?
Right. So if you think about academic tech transfer, you've got research that leads to inventions. Those inventions are protected with intellectual property, generally patents, but there are other types as well. And those patents are licensed out to companies. There are a couple of bottlenecks in there that people are concerned about. The first is research funding. As you might have seen, research funding is declining from a federal government standpoint. And at least in universities, over 59% of all of our funding comes from the federal government. It's that research expenditures that lead to the next invention. So that's the first concern. So that funnel can be as wide open, but if you've got nothing going in it, nothing's coming out the other side. That's the first concern. The second concern, more germane to this conversation, is protecting of that intellectual property. So again, universities come up with incredible inventions. They need to protect those because no company is going to invest the amount of money and time and energy needed to move that invention into a product without some way to protect that intellectual property. That is the crucial part. And some of the changes that have occurred in terms of what's patent eligible. I worked on an invention that identified two particular genes that would be a great indicator of the recurrence of breast cancer. So, a simple two-gene test. And again, early stage. Filed a patent application, moving this forward. Next thing I know, that type of invention is no longer patentable. It was patentable when we started. It wasn't patentable halfway through. That invention's never going forward. And hopefully there'll be other ones forward, but in the absence of being able to protect that, no company is going to move that forward. So I get concerned, and I know our members are concerned about the importance of intellectual property protection, and then you couple that with this post-serial challenges. Two patents that have gone through the process have found to be valid, are licensed to a company, and then they find out that under a completely different set of circumstances, now that patent's no longer valid. Well, that is going to keep that company from licensing the next piece of intellectual property going forward. So those are the concerns I have. Maybe I'll just end with kind of an example. So creation of penicillin. So you guys have heard this, a petri dish, left it too long, turns out developed penicillin. 1928. First person wasn't administered penicillin until 1942. No patent was filed, nothing went forward. They finally used it on a patient, used up half the amount of penicillin they had developed. And a couple months later, they had enough for 10 people in the United States. Someone developed a method to push this forward. and create this much more efficiently was filed in 1945, and you now have seen the impact of penicillin. If not for that, penicillin might not have ever seen the light of day.
Bob, is there a consensus among the VC, the venture capital community, about what needs to change for them to become more enthusiastic about investing in these sorts of things?
There's not really a consensus because venture capital firms themselves have kind of splintered in the same way that the investing process has. The large venture capital firms like New Enterprise Associates, which is the firm I know the best and do a lot of work with, has both a life science practice, a very robust life science practice, as well as a tech practice and a consumer practice. And certainly NEA and a number of the companies like them are strongly supportive of having a stronger patent system. The problem that we have in the venture world is every venture capitalist has had at least one company get up on the eve of financing and be taken advantage of by a strategically timed lawsuit that interferes with their financing, either knocks it completely off of the chart, which is, I had a client that had that happen. They were about ready to do an IPO. They got threatened with a patent suit, which had to be disclosed to the underwriter, and that was the end of the underwriting. And every VC has had something like that happen. And so part of patent reform from the standpoint of certainly the NVCA is some mechanism for addressing the strategically timed patent case, even if the patents are valid patents.
I want to encourage folks in the audience now to come to one of the microphones here and have address. We're going to leave plenty of time for questions and comments. So please, just if you line up at the microphones, I'll be happy to call upon you. We hear a lot about uncertainty leading to people actually feeling like other countries' patent systems are more reliable, that maybe they'll get their patent in Germany or some other place rather than here to start. Are you seeing that at the corporate level? Are other companies now saying, let's not mess with the U.S. patent, it's too common, let's go get a patent somewhere else? Is that a problem for folks?
So I will say, there have been some efforts to gather examples of that and look at that, and we did so at 3M, and we did find examples both in the EPO in Europe and in China where, and this comes back to the patent eligibility question, where we had applications for patents that had been rejected for on 101 grounds in the U.S. that were proceeding in each of those other patent offices. So yeah, I think, it ties in with Lori's opening remarks on where we are in the ranking of patent systems and innovation economies. This is a trend that goes to an issue of global competitiveness, and I think you can see it in terms of investment dollars, in terms of where R&D is taking place, and I think that those trends are going to accelerate if we don't look at some of these issues.
Are you seeing that? Are you guys seeing that?
It's certainly anecdotally correct. A number of lawyers and companies have told me that for them, the preferred forum for enforcing a patent today, if they can make it work in terms of the market, is Germany or the UK. China is coming along very rapidly as a country that will enforce patents, whether they're owned by Chinese companies or foreign companies. And we're going to see the growth of China because they're serious about becoming the dominant technology force in the 21st century.
And just to add to that, when I was in engineering, I spent a lot of time in China. We had Chinese customers for our chipsets and our licensing. And as of about 4 years ago, China started putting a real focus on invention, and there was all this anecdotal comments about the Chinese copy and such, but there's a lot of talent in China and a lot of very brilliant minds in China, and they're getting tremendous support from the government, both in terms of investment and in terms of their patent system, to encourage them to become the top patents.
They're also recruiting. They're recruiting entrepreneurs and scientists from other countries. There was a fascinating story in the Financial Times about a month ago about an Australian engineer that has taken a job in Beijing because the benefits were so attractive.
So we have a couple folks at the microphones. We'll start over here, and then we'll go over here. So you first. You just identify yourself and who you're representing today. There you go.
Hi, I'm Ellis Sudak, intern at Third Way, a little bit younger than most of the people here. But so my question's for Mr. Taylor. So you cited this stat that the rate of incorporation of new businesses for the first time ever is lower than the rate of destruction of new businesses. And so I've read the research on that stat. And so while that stat is correct on the total scale, the bulk of that business destruction, has been in mom and pop shops, the type of businesses that don't incorporate in Delaware, the ones that are named after the founders, the ones that don't really file patents. Whereas the rate of incorporation of high growth potential firms, the type that do incorporate in Delaware, are the ones that do file patents and drive the majority of our economic growth. Those firms continue to be incorporated at the same rate as they always have been. Given that this is true, how can you attribute the stalling of America's entrepreneurial engine to its weakening patent system?
It's a fair question, and all I can tell you is that I work with a lot of venture capital firms and with a lot of startups, and I have seen, and I've been doing this for 15 years, I did litigation in the early part of my career and gradually transitioned to more of an advisory role, and I've seen the shift. I've seen the numbers of new companies coming out of the VC pipeline that are just not interested in having patents. Primarily, that's the concern that I have, and if the reason they don't have patents is because the investors want a company that can get the liquidity in 3 or 4 years instead of 15.
Question over here.
There
you go. I think you got it.
Does it work now?
Yes, sir.
Okay, I'm Paul Morinville with U.S. Inventor. I'm also an inventor. I've got 20-some patents and pending patents that I cannot enforce in the United States. But luckily, I've teamed up with a company, and I've been helping them enforce patents in China. So, or we're working on that, and I've been talking to law firms, Chinese law firms, who claim that they can get all the way through trial in 12 or less months, and 90-some% of the, when you win, 97% of the time they grant an injunction. So you've mentioned Alice is need to be fixed, and PTAB needs to be fixed, and I absolutely agree with you. But I'm wondering what you think of, especially 3M. If a small inventor sues your company, should they get an injunction?
Well, so I think starting at your question about China, yeah. So that, especially I think in the specialized IP courts that they've now formed in Beijing and in Shanghai and in Guangdong, those cases tend to move very quickly, and they're developing their jurisprudence not in the face of an eBay decision or an Alice decision. And so, yes, you can get to judgment, and the success rate for patent owners is very high in those courts. I think there's still work to be done in terms of the remedies, really an effective damages award, and there's issues around the scope of the injunction. As to your other question, in terms of in the U.S., we at 3M and as part of a larger coalition of companies argued the other way on eBay. We argued the way that it didn't come out of the Supreme Court. I think the nature of a property right, like a patent, is exclusivity. It's maybe even a stronger case than for real property because of the limited duration of the patent right. And I think I think the nature of the patent owner, whether it's a small inventor, whether it's a big company. It shouldn't matter in terms of enforcement of that patent right. So yeah, if we got into a situation where it got all the way to a judgment and it went against us, I would expect that 3M would operate under the same rules as any other patent infringement defendant.
Other thoughts? We always thought that China has not really been very respectful of IP rights, copyrights, patents, and all that stuff. Is that changing now as they create more of their own IP? Are we seeing that change? Is that what we're seeing here?
Changing very rapidly.
Yeah, I would completely echo that. The engine that China is creating in terms of the number of new patent applications is stunning. It is absolutely stunning, and it will dwarf the amount of intellectual property elsewhere. Now the question is, can that be commercialized? That's the question. And here in the United States, our model's being followed elsewhere. And frankly, other countries are scratching their heads into the shooting of the foot in terms of the commercialization of our intellectual property due to patent protection changes. And so that's something that I'm concerned about, that we need to push forward.
Go ahead.
Susie, go ahead.
I just want to echo that. I see China, there's tremendous talent there. There's tremendous talent being brought in to China, and there's tremendous interest and movement in creating a patent system. I think with all due respect, my friends and colleagues in China, there's the protecting of other people's patents is not always the priority. There still is a little bit of a culture of copying is the best form of flattery. So that's another little kind of dark wart on the challenges in China. But just to add to that, I had the honor of going with Ambassador Thorne on his innovation tour of Southeast Asia about a year and a half ago, and we went to Indonesia and we went to Vietnam, and tremendous interest in how the U.S. in the past has done the innovation and kept the patent system going. And so it's not just China and Germany and such who are looking at recreating the model that we have had. It's all of these countries who are very interested in what the good things that the patent system has brought the U.S. and they are definitely not looking to copy some of the problems we have now.
Bob, you wanted to jump in.
Yeah, one point that's worth noting, and this is one of the statistics that was developed recently by the National Venture Capital Association. 20 years ago, 90% of all of the venture capital money in the world was spent in the United States on United States companies. Last year it was 54%, and it's declining still. So that's a statistic. Now there's lots of reasons for that, and one of them is the growth of other economies around the world. But a lot of that money is American money that's being invested in China and in Europe and in other places.
Question over here.
Hi, Peter Dio with Harvard University. This is for Steve mostly. So curious of what you've seen, what makes some universities better at or more successful in this enterprise than others? Is it simply a matter of luck in the laboratory, or simply a matter of resources, or are there sort of best practices or policies in place that have made some more successful than others? And then very quickly for the rest of the panel, I know, Steve, you mentioned the declining federal investment in research and the sort of the effects that has downstream. And I'm just assuming that companies like 3M and Qualcomm will immediately fill in the gap when the federal government stops that research. So if you guys just confirm that, that would be great.
I'm behind you, Steve. I'm behind you. I'm shaking my head.
I think that was the easy question. Yeah. But talk about why some universities are better at tech transfer than others, Steve, and what could be factors in that?
Right, and so it's important to realize there's a lot of different factors that go into successful commercialization of inventions. And again, if you think of the funnel, the first thing is, what is the scientific base that you have? Those inventions that are created, that's the raw material that technology transfer offices have to work with. Then it becomes a resource issue. Is that office staffed to the level that they can handle the amount of intellectual property developed? The second part, and the second or third part of this, would be, what about the patent budget? Again, if we go back to inventions are created, need to be protected and commercialized, those offices that might not have a budget to actually protect that intellectual property are hamstrung from the beginning in ever commercializing that intellectual property downstream. Then upon commercialization, now you have another element of risk, and that is infringement by others, perhaps serial patent challenges. And again, this is a resource-intensive issue. One of the great things about universities is some of that royalty money that comes back to the institution from inventions is then reallocated into that research enterprise and supports the next generation of inventions. So I think some of the universities that stand out reinvest that in the next generation of patent products. There's a lot of education of inventors. So there are a lot of different factors that fit to that. And I'll put a personal plug for Autumn. We do provide a lot of training for those technology transfer offices, such as your colleagues at Harvard.
And just to add to that, if you did a graph of the amount of money invested in research that was going up like this, you could see the number of discoveries in a parallel track. So it's very clear that the more you invest, the more discoveries you're going to create, the more opportunities you're going to have to find the next great drug, the next great technology.
Yep, and actually, I'll give you the number. $2.7 million equals an invention. And again, this is averaged over time, but there's an actual number. So, I mean, that couldn't be more accurate.
Right. Question over here.
Mr. Rhodes, you mentioned that venture capital was perhaps fearful of investing, and you mentioned that the Supreme Court maybe had done some not supported as you would have liked. Can you give an example or two that might help me understand that better?
You mean Mr. Taylor, right here. Yeah.
The question, I think, was to me.
Yeah.
An example of some Supreme Court decisions that I'm concerned about?
Yeah.
Well, certainly the decision in eBay essentially transformed what the Constitution says is an exclusive right into a non-exclusive right, into a right that other people can use and simply pay damages for. Courts are not issuing injunctions today to companies other than competitors. So if you are a licensing company and someone uses your technology, the best you can do is get some kind of damages or royalty, and that after a major struggle. That's an example. The Section 101 decisions, and there were 4 of them, have made it very difficult to get patent protection, reliable patent protection. Bear in mind that reliability is something that you don't know at the outset. It's something that you have to rely on at the outset, but are not going to find out how enforceable your rights are until you have to go to court to use them, or have discussions with other parties. And with the loss with the rulings in Bilski, Myriad Genetics, the Alice case, and there's one other one,
Mayo.
And Mayo. Those cases have just wreaked havoc with software industries and life sciences industries, particularly on the diagnostic side, and the protection of genetic discoveries. Myriad was decided 30 years after the patents issued on the BRCA1 gene that was the subject of that litigation. And it had long since gone off a patent. There were other follow-on sequence patents. But we had 30 years of capital formation built around the notion that we can get patents on gene sequences if they're isolated and discovered. And suddenly all of that evaporated. That's what I'm talking about.
Thank you.
Do others want to jump in on that? Any other additional comments there? We have about 5 or 10 minutes left, so if anybody has other questions or comments, please come to the microphone. I see someone right over here. Yes, sir.
Thank you, Patrick Kilbride with the U.S. Chamber of Commerce. I'm going to go back to a comment that Mr. Rhodes made about patent opposition. I think, supporters of the current system would have us believe that its intention is to clear the underbrush, I think is the term that's been used, of low-quality patents. But your comment suggested that, in fact, it's the most useful and attractive patents that are being targeted there. Can you comment further, or others?
Yeah, I think the statistics say that something like 80% of the patents involved in IPR are involved in concurrent district court litigation. And that makes sense. I mean, given the cost of these proceedings, it's not like European oppositions, which are very low cost and are used sort of as a way to help guide R&D efforts and to kind of clearance for development. These are really typically, given the investment required, part and parcel of litigation. So as a result, I mean, I look at the patents that we've had involved in IPR. These are patents that we are enforcing and then have drawn an IPR. And I think that's overwhelmingly true. These are not a random sampling of patents coming out of the patent office. These are ones that someone has thought were important enough to try to use, and someone else has thought were important enough to try to enforce. And so I think the fact that we are seeing, institution rates that I think are now about 70%, and once the institution is granted, you're overwhelmingly likely to lose some or all of your claims in the IPR. And there's the issue of the serial challenges that Steve just referenced. I mean, this really does, cast this air of uncertainty, unreliability, and a lack of quiet title over these most important patents that you want to use to secure investments in manufacturing and jobs, to commercialize the invention. And so, I think that that is a byproduct of not necessarily the original conception of what an IPR would look like. I guess the oil states case that'll be decided by the Supreme Court next term on the constitutionality of the procedure on its face will tell us more about that. But I do think, in particular, the way the system has been implemented through the rulemaking process sort of deviated from the original conception that these would be low cost, quick, and in front of expert judges as an alternative to litigation. They're now becoming, an adjunct onto litigation and are drawing these serial challenges. So you look at these, one final point on this, you look at this institution rate, and we read it's like 70%. But some of the most valuable patents, and especially in the life sciences sector where they're extremely valuable, draw multiple challenges. So if you have one patent and you get 5 challenges to it, and you win the first 4 and you lose the last one, according to the PTO stats, there's only a 20% institution rate for that patent, right? For the patent owner's perspective, it's 100%. Your patent is now subject to a proceeding, and the odds are very long against you that it's going to survive. So I think that's the nature of this sort of lack of reliability and quiet title in patent rights. And it makes for extremely difficult discussions. Susie might have something to add on this. Extremely difficult discussions with business leadership in determining where to invest in these commercialization efforts that we would hope would be secured by patent rights.
Anybody else have a comment on that?
Maybe I'll just echo a little bit just in talking about property rights. And, the way I sometimes think about it is patents are property rights. And so what's another property right but, a deed to a piece of land. You purchase a piece of land. You have a deed to that. It says that's your land. No one else can go on your land. You decide to build a 2-story colonial. Costs you a lot of money. You finally put that up. And then the next day, someone says, that's actually my land. You don't actually own that land. Well, is that person ever going to build another house on another piece of property? Will that company ever invest in the resources necessary to develop that next invention? That's really what panics me going forward.
Steve, since you're talking, one of the probably the most important actually the beginning of tech transfer was the Bayh-Dole Act that passed in 1980 that allowed universities and the inventor to take title of the patent as opposed to the government having it, and things just never got out the door. And all of a sudden this boom happened. We're starting to see now people saying, well, wait a minute, Bayh-Dole, doesn't that make people pay twice? They pay for the research and they got to buy the product. And what are we getting out of it? We, the taxpayer, we, the consumers. How do you respond to that? How do you think Bayh-Dole continues to be relevant here in the 21st century?
Sure. So, probably back to imitation is the best form of flattery. There are Bayh-Dole Act legislations being passed around the globe. So the effect of Bayh-Dole on our economy, and I talked about the numbers and jobs, is already clear. But let's get specifically to your question. Hey, you're a taxpayer. Why invest? Why have the Bayh-Dole Act? You're paying twice. So I'll give two quick answers. Number one, I was a taxpayer before. Well, maybe I wasn't, but others were a taxpayer before 1980. You were not getting any benefit out of your tax money. That tax money was going to universities for research, inventions were being developed, and that was it. So number one, you just had a big, ran into a brick wall. That's number one. Number two, now when those inventions are developed, those property rights are maintained by the institution with a perpetual license to the government. So it's not that it's completely in the university, but so now it's in the university, and now it needs to be commercialized. So you talk about the pay twice. Benjamin Franklin said inspiration or inventions are 1% inspiration and 99% perspiration. And I actually think that is a great example of inventions. Inventions are developed at universities, maybe with some NIH grant funding, totals $5, $10, $20 million, our money, a portion of our money. However, a drug does not take $20 million to develop. That's going to be $2.6 billion. You got your 99% to 1%. So I would say the Bayh-Dole Act has been extremely successful. You could see it throughout the world. And in the absence of the Bayh-Dole Act, certain intellectual property will never have been developed. You think that there's a tree that just grows drugs. And you could just pluck it off and it's easy as that. So anybody have any idea how many FDA-approved drugs or drugs are approved by the FDA every year?
40.
On the high end. 40 on the high end. 18 on the low end. So that is currently in our system over the past period of time. There have been as few as 18 new drugs developed. As you reduce the incentive to develop additional drugs going forward, that's going down, down, down. So those are the types of concerns I have. So I'd say the Bayh-Dole Act has been a huge success, imitated by others, and is the best engine for pushing our university intellectual property forward into the commercial sphere.
Bob, we have a question for Steve.
Fire away.
I've worked with about it in the last couple of years, at least half a dozen, maybe more universities. They all have different policies regarding the ability of their professors to start companies and commercialize the technology that the professor worked on with postgrad students to develop. And is my just my anecdotal experience is that universities like Stanford, which encourage their professors to start companies, seem to have a more robust pipeline of companies coming out than some of the universities that really won't even allow their professors to become part of a new company. What's your take on that?
Yeah, so there are a lot of pieces to that as well. Number one, individual policies at universities may be more or less concerned about implied conflict of interest. So you can imagine the issues that arise where a professor has a company, has equity stake in a company, and perhaps has their postdoc developing, furthering that invention. So you could see there's some apparent conflicts. And so those are managed well, but you've got to be careful with that. So sometimes there's just a moratorium on that. I think universities are moving away from that. I think more and more universities are recognizing the importance of having that inventor involved in a company. That being said, that inventor is generally not going to be the CEO of that company going forward. Now, they're a key element. They are the scientific brains behind that, but bringing in an entrepreneur is the next important stage, and to do that, you need to have strong patent rights that will attract funding that will allow the hiring of an entrepreneur.
So as we close this panel, just a quick comment, Susie. I was intrigued that with your students' activities, you had one of the choices for a career was political scientist, and I think given what we've seen in Washington the last 6 months, I think that phrase political science might be an oxymoron. But anyway, I want to thank our panel very much for being here today. I think what they have showed us, again, something I think we all appreciate, is the value of patents, and how patents are going to be handled is going to say a lot about where we're going to be as a country in the next 10, 20 years. And I think you've heard some interesting perspectives on that as we wrestle with these issues in the future. So please join me in thanking our panel here today.